Next, we're going to move to the Committee on Professional Ethics proposed amendments to the RPCs. And I think we have Chair Anderson here in person. And do we have Professor Holland on the phone? Oh, there he is.
I'm here. Good afternoon, everyone.
Good afternoon. Turn that mic on. There we go. Okay. If you just give me a minute, the internet changed from the waiting room to here, and I'd like to get on the internet site so that I'll have my materials.
Really? You know what's sad is that I feel like it's warm. Oh, my.
You're pointing to me?
It's not on.
Why?
I was on in there, but
You're on.
oh, okay. Says I'm not, but
What was the one you were using before?
it was the same one.
2.5 or?
The Netgear 92 or something.
Mm-hmm.
Let's see. Well, still saying I'm not connected.
Update now.
Is that what it's doing?
Installing up. Do not close it. That's why
I would just go out there. Can I try the Octopass again?
Try that one.
Yeah.
Yeah.
That's the bottom.
Do you have a hard copy of the meeting materials?
We have a USB on there because I think we have electronic.
I don't have it.
So while we're okay, there's some technical things. While we're awaiting, I want to take this.
Okay, go ahead.
There's somebody here with us that is
Should
a
ask
real
for, like,
unsung
go to
hero
Google or something.
that we don't give
Should ask you to
enough
confirm.
applause to, but I think a Rex really deserves a round of applause.
Yay, Rex.
Dan, did you have your microphone on when you said that?
I did. Yes, I did.
Let's see.
You did get me there. I still have nightmares. It's wanting to connect.
It's wanting to.
Yeah, it just needs to confirm. Because it should open a page and tell you to accept that you want, their service.
It was fine in the waiting room.
Yeah.
Hmm.
Okay.
Well, I can probably do this without it. So this says that it's connected.
Yeah. Let's just try and go there. Okay. It's just slow because that's active. There we go. All right. So
It's
you're
still
on.
snow.
Yeah,
Yeah, but I
it's
need to be
slow.
in this. Well, I can get most of it this way. Go into my files.
It's on.
Okay, I'm sorry for the delay. The internet's still not working for me, but I think I can get most of what I need through the files on my computer if you have questions. So good afternoon. I'm Pam Anderson. I'm the chair of the Committee on Professional Ethics. And so good afternoon, President Clark and the Board of Governors and the WSBA staff. I'm here today on behalf of the committee to speak to the proposal and our recommendation to amend RPC 1.5, 5.4, and 7.3. And I'm joined on Zoom by Professor Brooks Hollins, who with Don Curran served on the original subcommittee that analyzed this issue in 2019 and 2020, which led to the Board of Governors making a suggestion to the Washington State Supreme Court for these proposed amendments in 2020. As mentioned, the Board of Governors previously approved the same recommendation for suggested amendments that are before you today. The amendments clarify and cure inconsistent and confusing language related to whether a lawyer can pay a fee to a lawyer referral service and under what circumstances that's appropriate. Two of the amendments, the ones to 1.5 and 5.4, are largely technical and really do just cure some inconsistent and incongruent language in the existing rules. The amendment to RPC 7.3 is slightly more substantive, and it clarifies that the fee paid to a not-for-profit lawyer referral service may be in the form of a percentage of the fees earned, rather than just a flat fee that the lawyer referral service charges to the lawyer to which it refers a case. And I want to just point out that at least two county bar associations, King and Tacoma Pierce, currently already have lawyer referral services where the lawyer is expected to remit a portion of earned fees. They use slightly different methodologies, and some of them are, one of them is dependent on the magnitude of the fees earned, for instance. And so those fees that are earned support the work of those bar associations. And the CPE, the Committee on Professional Ethics, believes that clarifying this arrangement as permissible will support access to justice, because many lawyer referral services, and not just the ones that are run by county bar associations, serve constituencies that historically lack access to justice and lawyers. Two examples of that I can give you would be, for instance, limited English fluency. It might be hard for them to for those constituents to tap into one of the county lawyer referral services or other things that might be available for people to find lawyers. So that's why we're really supporting clarifying that kind of arrangement is appropriate when you're talking about not-for-profit lawyer referral services. And now I'm going to turn it over to Professor Holland, because he has background. He was on the original subcommittee, and he and Mr. Curran did quite a bit of work contacting constituents and or people who might be interested in providing these kind of lawyer referral services, contacting county bar associations. And so he's going to provide some background about what he and Mr. Curran did prior to the Board of Governors originally approving these amendments. So So with the president's permission, I'll turn it over to Brooks. I think you have permission.
I was waiting, but on fur. Good afternoon, everybody. Thank you for allowing us to speak to the proposal that we have shared with the Board of Governors. As you heard from Chair Anderson, this is the second time this proposal has come in front of the Board of Governors. The Board of Governors previously approved it to recommend to the Supreme Court, and it was kicked back to us after the Supreme Court approved other very global amendments to Title VII dealing with all of the lawyer advertising and communication rules. So we're back here again. And I just wanted to give you a little bit more of a perspective on the lineage of this proposal to help to clarify why it's in front of you in this particular form. The proposal started as an inquiry from an out-of-state nonprofit referral service for vulnerable victims, focusing on domestic violence and similar types of cases, who wanted to see whether they could bring their referral service into Washington State. And they had looked at the provision in 1.5 that we're proposing to amend, and understood that it might mean that they needed the permission of the Washington State Bar Association to do this kind of referral work, and that 1.5 was some sort of governance provision for the WSBA to be controlling these referrals. So it came to us on the CPE, and Don Curran, as you heard, our former great colleague on the CPE, and I took a closer look at it and first realized that the whole concept of referral fee regulation shouldn't even be in 1.5 in the first place, because this is a provision, as you know, that deals with the division of fees between lawyers who are not in the same firm, who are dividing a client fee for parceled work between the lawyers who are not in the same firm. This is not the provision that deals with referral fees, including referral fees to folks who aren't lawyers, which was the situation here. So we already started to identify an anomaly that maybe needed to be addressed. And as we looked into the language about the WSBA and county bar associations, we realized that we could not find a consistent understanding of what that language even meant between the WSBA and the county bar associations. And a number of county bar associations were engaging in very different types of practices relating to referral fees. Some of them were not even aware of this provision in 1.5. And to our understanding, the WSBA did not have any type of regulatory mechanism in place for overseeing referral fee programs in Washington State as a part of this rule. So Mr. Curran and I were thinking about how we should come back to the committee with the idea of moving this kind of regulation to where it would belong, which would be in a combination of 5.4, dealing with constraints on client fees other than to lawyers, and to 7.2 at the time, which was the provision 7.2b that dealt with referral fees. And we started looking a little bit more globally at practices that were out there, including out of state. And we focused on some provisions in Arizona, for example, that were trying to use some reform here to open another space for increased access to justice for nonprofit referral services that are connecting clients in need of different kinds. And Chair Anderson's already offered some examples to lawyers who might be available to do that kind of work in Washington, but to recognize that with this nonprofit model, perhaps some flexibility in the fee system might encourage or incentivize more of these connection points. So we borrowed some of these models to propose that not only should we move this regulation of referral fees from 1.5 over to 5.4 and 7 at the time 2, now 3, but that we should propose a reform to include the opportunity, as Chair Anderson described, for a percentage of the client fee itself to be permissible for the lawyer to share with a nonprofit as an exception to the general prohibitions on fee sharing with non-lawyers and offering anything of value to somebody in exchange for a referral because of the limited but hopefully access to justice focused nature of these referrals. And you could see that we included some specific limitations that are designed to minimize the risk of abuse. That is the basis for these prohibitions in general, governing the amount of the fee that could be charged, making sure that the entities are nonprofit in an identifiable way, and to ensure that the client doesn't subsidize the referral fee by an increase to the overall fee the client pays, that this is something that would be between the lawyer and the nonprofit referral agency. When it came back to us from the Supreme Court, we weren't really sure entirely why, whether the Supreme Court had passed on this proposal on the merits, but we thought it simply could be because the proposal no longer aligned with the new structure of Title VII. RPC 7.2 doesn't exist anymore, and we had proposed to amend RPC 7.2. So we've rewritten the proposal to address these global changes to Title VII, but the basic concept and provisions are the same as the one on which the Board of Governors passed before. I don't know at this point whether the Board of Governors would be doing de novo review or abuse of discretion, or what the process would be, but we're back here to answer any questions you might have. We thought that background might be helpful for any governors who were not present for the previous proposal and presentation. Thank you for the time.
Okay, let's open it up for any one here want to make anything to ask or a motion, or
I so move.
it's been moved.
I've got a question.
Okay.
Oh,
Sure,
never mind.
let's do that.
I withdraw my motion.
Thank
Professor
you.
Holland or Ms. Anders, I'm curious, based upon the, I guess this is the comment, does the lawyer have to establish that the entity is a 501 exempt entity? I mean, how does that play? I guess the question is because I can see a lawyer get in trouble. They got a referral from some source, then later on becomes it's not a as I understand, a tax exempt service. So how do you make sure that that is done appropriately? I mean, what are the requirements?
I think that's a great question. And honestly, it's not something that we have thought about, but my assumption would be that it would be the lawyer's burden to determine that. I don't think that's a difficult determination to make. People who are 501c3s certainly have letters of recognition of that status. Washington not-for-profit entities register with the Secretary of State's office, and most of those entities publicize their status very liberally in order to, because that provides assurance to people. So, but I do think it would be the lawyer's, in my opinion, it would be the lawyer's burden to ascertain that.
And if I could just add, Chair Anderson, because this issue did come up during the first iteration of this proposal when Don Kern and I were presenting it to the committee. And we went back and forth a little bit on exactly this issue of whose burden the determination should be and how we should try to define it. At first, we defined it exclusively by the IRS status or Washington Nonprofit Corporations Act status of the entity, but we realized that might be a little too constraining, particularly for organizations outside of Washington, and might put a little bit too much of a burden on the lawyer. You can see we expanded it to include any organization referral service sponsored by a nonprofit organization or any organization that also qualifies under the programs permitted by Rule 6.5. And to that point, we did decide that if the lawyer is going to be sharing client fees as a payment for a referral, as an exception to the baseline rules, the lawyer should have to make the effort reasonably to confirm that the referral service meets one of these definitions. But we opened it up a little bit to avoid placing too much of a burden on the lawyer to try to confirm IRS status or something. But it is an issue on which we went back and forth, and we settled on this balance.
Great. Thank you, both of you.
Okay. Are there more questions to ask? Seeing none, is there the motion then that was going to be made previously?
I so move.
Second. Okay. As moved, as seconded. Any discussion? Okay, hearing none. I think let's go to a vote here. Thank you.
All right. Motion to approve the recommendation from the CPE. Governor Adewale, not present.
Aye.
Oh,
Aye.
sorry. Governor Angela? Aye. Governor Boyd? We'll come back to you. I did. Okay. Governor Couch? Not present. Governor Dresden? Not present. Governor Fay? Governor Kading?
Aye.
Governor Wynn?
Aye.
Governor Petrasic?
Aye.
Governor Pertzer?
Aye.
Governor Rathbone? Oh, she just came back. I'll come back to her. Governor Sayani? Aye. Governor Stevens?
Aye.
Governor Williams-Ruth?
Aye.
Governor Rathbone, we're voting on approval of the CPE's proposal. Do you want to vote?
Abstention.
Okay. Governor Rathbone, there's a motion to approve the recommendation of the Committee on Professional Ethics. I know you missed the discussion. Would you like to vote? Do you want to abstain? Do you want to be marked not present?
Listen, I vote yes.
Okay, great. Motion passes unanimously.
Great.
Thank you for your time.
Thank you for your time.
Thank you so much.
Thanks so much, everyone. Take care.
Thank you.
So we're running ahead of schedule again. Let me take a quick pause.
A break for 10 minutes or?
Yeah, let's break for 10 and try to.
Sure. Yeah.
So we're going to take a 10-minute break and I'll see if I can get, our presenters are coming early, but I'll see if I can get them even earlier. So back at 2:20.